Hi, I'm Carrie Payne from Business Depot Legal. Perhaps fortunately in some circumstances, people are able to make a valid will without having to obtain advice from a lawyer. This has probably become more frequent due to the rapid increase in availability of a variety of do-it-yourself kits and information sources setting out the requirements of a simple will. You see, for a will to be valid, there's actually very few requirements. Number one, it must be in writing signed by the person making it. Number two, it should be dated at the time of signing. And number three, two independent people over the age of 18 should witness the signing of the will. However, most states have introduced legislation to grant the court powers to set aside these formal requirements and allow more informal documents to be evidence of a deceased's intentions. While these powers may make it seem like you can make your own will, this doesn't mean that you should make your own will. Proper estate planning should be focused on reducing the emotional and financial burden on your family if you're not here or you can't make decisions. It's important to note here that most of the informal will cases have to be proven in court at great cost. We here at Business Depot Legal think that there are lots of things to consider when you are developing your estate plan. However, let's talk about two of the key philosophies relevant when creating your estate plan. Probably the biggest threshold issue to determining how your estate planning document should be crafted involves exploring which of the two values is most important to you. Number one, certainty. Do you want absolute certainty that your wishes will be followed through? Or number two, flexibility. Do you want to leave the people you trust some discretion to do whatever is appropriate at the time of your passing? Certainty is a good philosophy, say for example, for blended families, as it ensures that the outcome you want will come to pass. However, in the rigidity of the plan are lost opportunities for your beneficiaries to make decisions that will materially benefit them, based on their circumstances and yours at the time of passing. Flexibility, while being very beneficial in terms of creating opportunities rather than absolutes, must be tempered depending on your circumstances. It's critical that those reviewing their estate plans are aware that the process of estate planning should be holistic. Your wills and powers of attorney only cover those assets that are in your own name. Care should be taken and advice obtained to ensure assets outside of your estate, such as those held in other structures, for example trusts and companies and superannuation, are directed to align with your wider estate planning objectives. A carefully crafted estate plan should ideally be robust enough to avoid you having to frequently update your documents. However, there are many things that affect the appropriateness of your estate planning documents, largely based on a material change in your circumstances, those of the beneficiaries, or the law affecting your estate plans. Ultimately, the best way to ensure your documents remain appropriate is to ensure you have your documents regularly reviewed with your advisory team and update them as and when appropriate. Get in touch with us at Business Depot Legal for a chat at businessdepot.com.au/legal.